Can a prenup be challenged or invalidated in court?
In New Jersey, either party has the right to ask the court to set aside a prenuptial agreement, but it is very difficult to secure that relief in the state of New Jersey. Functionally, you must prove that you were under duress at the time that you entered into the prenuptial agreement and that enforcement would not otherwise be fair. The legal standard for that is what we refer to as unconscionability. That means the circumstances leading up to the enforcement of the prenuptial agreement are so onerous that no one should be held to the standard of actually knowing what they were doing and being bound by the terms of that agreement. That usually focuses the court's attention on how close in time to when you got married did you sign the prenuptial agreement. So it's always best practices to have several months between when you sign and start negotiating your prenuptial agreement and when you actually get married. For those people that sign on the dotted line hours before the marriage, those agreements are at the greatest risk of being set aside because the court would look at that and say that the person who had the most to lose from the prenup was essentially coerced into signing the agreement because everyone's there and you're about to get married. So it's very important that you speak with your New Jersey family law attorney to make sure that you comply with all of the statutory requirements to have an enforceable prenuptial agreement, such as full economic disclosure, both parties having the agreement reviewed by an attorney or knowingly and voluntarily waiving the right to do so, and that you adhere to the appropriate guidelines around timing of signing your agreement to make sure that the agreement is enforceable. But if you had any deficits in that regard, you should speak with a New Jersey divorce attorney about whether or not you have grounds to set aside the prenuptial agreement.